Evening, everybody. Yes, we have chosen today's topic to be number one: arrest, grounds of arrest, remand, bail applications, both in bailable and non-bailable cases, anticipatory bail, and cancellation of bail. Who are the authorities who can entertain these applications? Isn't it? So we learned that the criminal law is set into motion by filing a first information report, which is now under section 173 CR of the BNSS, which was originally under section 154 CRPC, in respect of cognizable offenses. So I had requested you to note down the fine distinction between cognizable offenses and non-cognizable offenses. Cognizable offenses are those offenses where a police officer cannot, where a police officer can investigate and arrest without the order from the magistrate, whereas in cases of non-cognizable cases, the police officer has no power to investigate nor arrest the accused person. Okay, these definitions you will find you should remember it under the provisions of section 2. Now section 2 has been substantially amended. Now you will find it section 2 खोलेंगे आप section 2G defines cognizable offense. I won't be reading it, but make a mental note of it. Then non-cognizable offense is defined under section 2O, where the police officer has no authority to investigate the offenses. So apart from the classification of the offenses, cognizable and non-cognizable, you should also bear in mind the offenses which are bailable offenses and non-bailable offenses. Bailable offenses, non-bailable offenses are defined under section 2 subclause C of the new act. Yeah. Apart from cognizable, non-cognizable, bailable, non-bailable, we also have the classification of offenses which are known as a compoundable and non-compoundable offenses. Now, this expression compoundable, non-compoundable, you will not find in section 2, but you will find under the provisions of the earlier section 320 CRPC, take down, under section 320 CRPC, now which is presently, you have to help me, Saili, in this. See, अब देखेंगे आप section 327 what offenses are compoundable and what, yeah, 285 of the present act. Yeah. Section 320 CRPC. Yeah, section 320 now equal to 359 in BNS, because the act is it's not possible to lay your hand immediately. You will require assistance. You have to compare. There's a comparative table. You please keep it with you, along with you. Section 359 आप खोलेंगे, you will come to know what are the offenses which are compoundable and non-compoundable offenses. 359. Yes, is it okay? Yeah. 359 makes a reference to a table. It says that the offenses punishable under the Bharatiya Nyaya Sahitya specified in the first two columns of the table. There are two columns given here, are compoundable offenses. I am giving you example. Compoundable mean the offenses can be settled between the parties. That is number one, for example, voluntarily causing hurt, which is an offense now, which is an offense under section 115(2) of the BNS, which was formerly under 323. Now it is a compoundable offense, isn't it? The non-compoundable offenses, they are not given the definition. whatever offenses which are not mentioned, such as murder, rape, dacoity, these are not mentioned in the caption of compoundable offenses. They become non-compoundable. You cannot compound them. It is not possible to uh, uh, can, what you call it, parties cannot enter into an agreement for settlement. Consent terms cannot be filed like in civil cases. They cannot be compounded at all. Even the court cannot give you permission in these matters, serious offenses like murder, dacoity, rape. Whereas in compoundable cases, you can directly uh, take the permission of the court and say, we are compounded the offense, settle the matter. That can be done. So the classification of the offenses under section 2, or you run it here: cognizable, non-cognizable, bailable, non-bailable, and offenses which are compoundable and non-compoundable. Okay. Then we learned that here, pursuant to the first information report, which was earlier under section 154, now under 173, a report, the police officer take cognizance of the cognizable offenses, and he has a right to arrest if the information discloses cognizable offenses. Now, what are cognizable offenses, non-cognizable offenses? You can see the table. You can see the schedule one first schedule of the CRPC after the provisions of section 531. 531 is the last section. That's a repeal section, repeal and saving section. Uske baad you will find it here in the CRPC, the classification, the first schedule. First schedule gives the classification of the offenses. Number one, first के अंदर आपको section मिलेगा. What section under the IPC, BNS? Then number two, what are the offenses? They are normally starting alphabetically, starting with the abatement, so and so. Then the third is what is the punishment which is sought to be imposed for the crime. Number the fourth category, cognizable or non-cognizable. When you open your first schedule, you will come to know this. Number one, offenses. Number one, section of the offense. Number two, what a description of the offense. Number three, the punishment which is inflicted for the section. Number four, item number four, the nature of the offenses, whether they are cognizable or non-cognizable. Generally, under the other acts other than the Indian Penal Code, offenses punishable up to 3 years are considered as a cognizable, non-cognizable offenses, and punishable more than 3 years are a cognizable offenses. But not this will not apply in BNS. Even in some of the cases, maybe outraging the modesty of a woman, punishable for 2 years. Still, the offense is cognizable and non-bailable. So that is not the yardstick. Then the fifth column deals with the bailable or non-bailable. Bailable, whether bail can be granted or cannot be granted. It doesn't mean non-bailable cases mean you cannot get the bail. Yes, get. In bailable offenses, the police officer has a right to grant bail. If not the police officer, the magistrates grant bail. In non-bailable offenses, the police officers do not have power to grant bail. I will deal with it. Only the magistrates or the court of sessions or the high court, they have the power to grant bail. Now, the last column is dealing with by which court it is triable. So earlier we learned here the classification. I mean, what are the criminal courts? In which court the trial can take place? Is a court of session, judicial magistrate first class, judicial magistrate second class. So these are the courts classification. Of course, executive magistrates are not courts within who can try, who can take evidence. Executive magistrate, they may be able to try some petty cases, but not the cases which are punishable with higher offenses. So please remember to take out your first schedule, which is after section 531, that is repeal and saving. Earlier in the CRPC, we had last section was 484. Now this BNSS has added more section. Okay, this is the classification part of the offenses here. Now, when a first information report is lodged under 173, formally under 154, the police officer Of course, we have mentioned to you the police officer cannot blindly arrest you. He is required to hold preliminary inquiry. Then he will also required to issue notice to the accused person. Then go ahead with it. Now, the arrest provisions, arrest provisions are given under the BNS and CRPC, section 35 now. Formerly, it was section 41. Please note that. The chapter 5 deals with the arrest of a person when the police officer may arrest without warrant. So these are the cases where the police officer, section 35 deals with the arrest powers. Now, under section 35(3), the police officer is required to give a notice to the accused person arrested. The person sought to be arrested cannot be arrested without giving a notice in offenses which are punishable up to 7 years. Please note that. Now, that expression you will find in what cases the police officer can arrest. Section 35(1) के अंदर चेक करेंगे आप. It is mentioned that here where the police officer has a right to arrest in offenses which may be less than 7 years and extend to 7 years. Now, which mandates that here the police officer is required to give notice under section 35(3) to the accused person before arresting him. Before the arresting him, that first information report has been registered against you. Information has been received, and seeks an opinion and gives an opportunity to the accused person to come and give explanation. This is earlier section 41A of the CRPC. Please note that here. Then after arrest ke baad, you know that here the police officer, now section 58 of the BNS now, earlier section 160, earlier section 58 section, it mandates that here the arrested person cannot be kept in custody for more than 24 hours. All of you know that. This is against the principles of Article 21, 22, 2 of the Constitution of India, and also against the spirit of the provisions of this earlier section 57. Now it is section 58. He cannot be detained for more than 24 hours. Now, what is the in 24 hours? In 24 hours, you cannot complete the investigation. All of you know that here, isn't it? Then, when a person cannot be kept by the police officer, he may have been arrested in Delhi, he may be arrested in Ahmedabad, maybe in Mumbai, or maybe in Bangalore. He is sought to be prosecuted in Calcutta. 24 hours time to be excluded the traveling time. Please note that here. Traveling time to be excluded. Then the next day, he is required to be brought before the magistrate to legalize the custody. Because the custody of the accused person with the police officer after 24 hours becomes illegal. He has no right to detain. Custody can further be extended only with the permission of the judicial magistrate. Please note that here. That procedure is now, you will find under section 187, which was formerly section 167 CRPC. This is a very, very crucial section which you are required to know that here. Give me Anupam Kulkarni's statement. Yes. Yes. Some of the salient features. Now the remand, what is the purpose of the remand? What is the purpose of the remand? Number one, for extension of the custody of the accused person. Number two, to enable the police officer to seek the further custody of the accused person. Either naturally the police want the custody in the magistrate's custody because they want further investigation. In 24 hours, you cannot expect any police officer to complete the investigation. But he has to, at the time when the accused is brought, when the police officer comes next day within 48 hours, what are the requirements he has to comply? Number one, he has to bring the accused to the magistrate's court. Number two, the police officer has to bring his case diary. Case diary is defined under section 172 of the CRPC. Please note that. Make a note. 172. Now are these? 192. Now section 182 of the BNS. 192. No, 192 of the BNS. 192. The case diary, the accused or the lawyer will not be permitted to see the case diary at this stage. Only the magistrate will go through the contents of the case diary. The police officer has to metically write down when did he receive information with regard to the commission of a cognizable offense, what are the steps he has taken, and why, whom has he arrested, what is the recovery done, whether any identification has been done, whether any statement of the persons are recorded. He has to convince the magistrate, judicial magistrate, further custody is required of the accused person for a period more than 15 days to interrogate him. Formally, under section 167 to CRPC, the maximum magisterial custody which could be granted by the magistrate was 15 days time. But now there is a substantial amendment to the provisions of section 187, which now gives more power to the police, because the government of the day realized that here it is not possible for the police officer to investigate the crime either in 24 hours or even in 15 hours or in 15 days time, because there may be conspiracy involved, accused may be in different countries, different part of the India, statements to be recorded, some people have fallen sick, they are hospitalized, because and the accused persons, by taking, because many of you know that many of the lawyers advise the client, police is coming to arrest me, number one, either you go to the court for obtaining anticipatory bail. But if they feel that the courts are not likely to grant anticipatory bail, bolenge inko please get him admitted in hospital. Under the CRPC period, when the CRPC was in operation, a person, accused person, while in custody, while in a hospital treatment, for example, 15-20 days, the police officer loses the opportunity of getting in custody of the police. Then what does the magistrate do? 15 days are over now. Now I will put him in judicial custody. I will not give you the custody. Now, to prevent this kind of misuse on the part of the accused person who will deliberately take admission, because this was discussed in Senthil Balaji's case also, Anupam Kulkarni's case. There are two leading cases. Number one, Anupam Kulkarni's case, that is a well-known judgment reported in EIR 1992 Supreme Court, page number 1768. That all of you go through that here. Yeah. And Senthil Balaji's case is a recent judgment, that judgment of the Supreme Court given during the COVID period time. So in both these cases, the courts have held that here, the police officers cannot claim custody of the accused person for more than 15 days. Now, both in Anupam Kulkarni's case as well as in Senthil Balaji, both the accused person took admission in hospital. Bole 15 din ho gaye abhi. So we cannot be sent to the police for investigation. So police have become helpless. So in this scenario, the legislature has redrafted the provisions of a remand, section 167 ki jagah they brought 187. Under 187 CRPC applies to the custody of the police for investigation is now extended from the initial 15 days now, 40 days and 60 days. Now the police officer can also, the magistrate can also give intermittent custody. There is no need to give straight away 15 दिन का custody में जाइए आप जेल में, the court may say that I am granting you 2 days police custody or 1 day jail custody. So this custody arrangement is now altered now, which was earlier not available, So please note that here section 187 to some extent impinges upon the fundamental right of the accused person under Article 21 and 22 of the Constitution with regard to arbitrary arrest, and it is possible the police officer may misuse it. Now, earlier the accused persons were misusing under 167(2). Why? Because only 15 days can their investigation should be completed. Otherwise, the accused is being sent to judicial custody. So, custodies are two types: judicial custody, which will be a custody before the magistrate. So, they will not be, police officer cannot forcefully take extraction demand. They cannot terrorize the accused person. Now, fortunately, the Supreme Court has said that here to minimize the torture and transparent, every police station must have a visible cameras, isn't it? CCTV cameras are held to be mandatory. Of course, many police stations do not have it. It is now made mandatory. Even recently, the Supreme Court reiterated that contempt action will be taken against the police officer if they do not have police camera. So, to mitigate the hardship and to give concession to the police officer, the period of remand has been now extended from 15 days custody. They can seek a custody up to 40 days and 60 days, because you know that under the provisions of the remand, the police officer maximum period the accused person can be in jail is for a period of 60 days and 90 days, depending upon the nature of the offense. If it's a murder case, if it's punishable for more than 10 years case, maximum period of 90 days within which charge sheet must be filed. Otherwise, the accused person entitled to get a default bail. Statutory bail mil jayega usko, provided that he is willing to give bail. And in other cases, offenses which are punishable less than 10 years, 60 days is the maximum time given to the police officer to complete the investigation and file a charge sheet. Now that period has been retained in section 187, that has not been disturbed. But now what is altered is the custody to be given to the police officer. Instead of 15 days, now they have altered it in the subsection 2 of section 187. You can see that here to 40 days and 60 days. Underline the 40 days. Now the expression, give me that analysis. In section 167.2, in section 167.2, earlier they have omitted the expression otherwise than in police custody. In the new section, you will not find it. In the new section, you will not find it. Otherwise, the magistrate can extend the custody. That has been taken away. That means the magistrate is empowered and the police officer is justified in seeking custody intermittently beyond 15 days. Beyond 15 days, and it can stretch up to 40 days in cases where punishable up to 10 years, where the charge sheet period is 60 days, 40 days the custody हो सकती है. And in murder cases and case offenses punishable about 10 years, the custody of the accused person can be stretched and kept in police custody for 60 days. Earlier, it was only 15 days. Now, this is the drastic amendment in the remand provision which you should maintain, which you should take note of. Whereas on the earlier section 167 to maximum period was 15 days period. After 15 days period, magistrate has no right to give the custody to the police officer. That is why there is a substantial amendment. Now let us see, some petitions have been filed in the Supreme Court challenging the constitutional validity of section 187 2 and 3 with regard to giving custody for more than 15 days period. What the Supreme Court will do, because according to the petitioners, it violates the rights of the accused person under Article 21 and 22 of the Constitution of India. For balancing the rights of the police and also the balancing the life and liberty of the accused person, what does the Supreme Court will do? We'll have to wait and consider. This concern was raised in Anupam Kulkarni's case and Bhatt Singh's case, which Buddha Singh case, which is also in Senthil Balaji's case. In one of the matter, before the Supreme Court during COVID time, the Supreme Court took the view that the Anupam Kulkarni's case requires reconsideration. Now, reconsideration may become infructuous now because the Parliament has passed Bharatiya Nagarik Suraksha 2023, which is now in operation, isn't it? Section 187 ke andar automatically custody has been increased period. So mind you that. So you learn that here the law is set into motion by presenting a FIR, section 173. Then the right of the police officer to arrest the accused person under section 35. Notice to be given to the accused person. Of course, grounds of arrest also to be required to be furnished to the accused person. Please note that when arrest is sought to be done, it is mandatory for the police officer to prepare the memorandum of arrest, to have at least one witness from the family of the accused person. If the family person is not available, at least one respectable person from the locality. Accused must be told that here you have a right to inform your family members, and grounds must be furnished. If the grounds are not furnished, the courts are now quashing the arrest as illegal and be set aside. Okay, that is the arrest part. For 24 hours, beyond 24 hours, the police officer cannot keep the custody of the accused in police custody, for which he is supposed to seek a remand order from the judicial magistrate. Please note that. The no sooner, no, yeah, you know that no sooner the police officer receive the first information report, it is mandatory for him to transmit the first information report to the magistrate, isn't it? So many times there are many complaints are given that your police officer is not giving us a copy of the first information report. How do we apply for bail? How do we go for a motion? Now the court has now made it mandatory. Copy must be furnished. Otherwise, in the previous, informally under the CRPC, what we used to do, yeah, young lawyers or maybe everybody, go to the magistrate's court because it is mandatory under section 155 CRPC. The police officer transmitting the report to the sending to the magistrate's office. So from there, we used to make application for bail or quashing, make certified copies and obtain it now. Now, fortunately, the new provisions of BNSS makes it mandatory that the police officer must provide information and must give the grounds and furnish copies, everything here. So, no sooner the accused is arrested and is brought before a magistrate, a remand is not an empty formality. It is not merely a given right to the police officer to seek custody. The accused person also has a right to make an application for bail at this stage. Please note that. You may take up the plea that here, the accused person has been wrongly arrested. The charges which have been levied against him are concocted, fabricated. You may take up the plea that the alleged offense is committed in Mumbai on so and so date. You may take up the plea of alibi. I was in Bangalore on that day. Of course, my incarceration is totally illegal, violative of Article 21 of the Constitution of India. My right to life and liberty will be violated. What would the police officer will achieve by keeping me in custody for more than 24 hours? He ought to have completed the investigation in 24 hours as per the mandate of the law, which he has not completed. I am entitled to bail. So you can make the application to the magistrate on the ground that you are a person, respectable citizen. Number one, you have firm roots in society. You are not likely to you are not risk flight to the police officer. You are not going to flee away anywhere. And you will give undertaking to the magistrate that I am ready and willing to participate in the investigation as and when required. I am prepared to surrender my passport and I will not leave the country without the permission of the court. I am a family man. So it is therefore desirable that my life and liberty under Article 21 should not be violated. So the accused person can make this application for bail at this stage of the remand also. Please note that it is not necessary you have to wait till you are arrested, completion of the investigation only can make the bail. Immediately the provision relating to bail, they come into action, they can be pressed immediately, no sooner you are arrested. And there are many cases, the advocates, we have gone to the magistrate's court and the residents, there are already a magistrate. No sooner the person is arrested in the morning, you can go to the magistrate, house residents, and seek bail on various grounds, legitimate grounds, which are available in the eyes of law. So there is no bar. The magistrate has the discretion whether to grant the bail or not. His powers are extraordinary here. Of course, these powers are to be exercised sparingly, with the great circumspection and caution in a judicious manner. It's like a power of a civil judge granting injunction. Balance of convenience, prima facie case. Here also the court will see that the nature of the offences involved, the whether the accused person is likely to, is a flight risk, will he cooperate or not, how the gravity of the offense. Of course, in many cases, Supreme Court says that gravity of the offense is not the consideration for refusal of a bail. Bail is a matter of course and jail is exception. That is the scenario. So, after the first information report under 173, then provision relating to arrest by the police officer without a warrant, then remand procedure under the provisions of 187. The next topic which will come here, which will go simultaneously and in the court of law, is the provision relating to grant of bails. Of course, these bails are under the CRPC. They are kept under section, what do you call it? Under the provisions of under the provisions of 436, 437, 438. Now, under the provisions of CRPC, under the BNS, they should have corrected it. According to me, they should have corrected it. Now, the provision relating to bail are section 478. 478 in chapter number 35. Please note that here. Provision relating to bails and bail bond. Now, we'll discuss here who can grant bails here under this provision. Now, under this provision, 478 CRPC, which is equal to section 436 CRPC. 478 BNS is equal to 436. These are bailable offences where a police officer, station master himself can grant bail. Or if he doesn't grant it for reason A, B, C, most of the police officers are reluctant to grant bail, which is not correct. But the magistrates have power to grant bail under section 436 CRPC, now under 478 CRPC, in bailable offences. Now we learned it, what is bailable offences. I went through the provisions, I read it to you. Now the next topic will be bail in non-bailable offences. Non-bailable offences, who can grant bail? That was section 480 BNS. Earlier it was section 437 CRPC. 437 CRPC. Now if you open your section 480, when bail may be taken in cases of non-bailable offences. Now, a judicial magistrate first class has power under this section to grant bail to any person who is arrested in non-bailable offences. And cognizable, of course. Non-bailable offences, more or less, they are almost cognizable cases. In such cases, though the CRPC BNS says that even if the offense is committed of death, life imprisonment, magistrate has power to grant bail, offenses punishable with death or imprisonment. Shall not be released if there is appears to be reasonable ground to believe that magistrate doesn't grant bail in such cases. But there are some judicial pronouncement which says that here, where because the magistrate ke paas he is brought first, the moment the accused person is arrested, though the maybe offense may be triable by the court of session, but he doesn't go to the court of session immediately. He is brought before the magistrate first. Magistrate is the authority for collecting evidence, because collecting evidence, magistrate is given very wide power under the old CRPC, section 437 case of the, he can grant bail in even cases punishable up to life imprisonment, death. Now the provisions under section 480 says that here he cannot grant bail, magistrates cannot grant bail. Now the wording say that when any person accused or suspected to be commission of non-bailable offence is arrested, detained without warrant by an officer in charge of a police station, brought before the court other than High Court and Court of Session, he may be released on bail. But now, but says subsection was, but such person shall not be released if there appears to be reasonable ground for believing that committed the offence of death or life imprisonment. That is an exception. Number two, person shall not be released if such offence is cognizable offence and had been previously convicted or punishable with death imprisonment. There's a bar or punishment more than 7 years' time. Then the proviso say, but the court may direct the person referred to in clause 1 release on bail if he is a child, woman, or a sick person. So there is no embargo. Magistrate gets power to grant bail in cases of death penalty and life imprisonment, in case the accused is a child, in case the accused is a woman, in case the accused is an infirm person. Please this note the category of 3%. If the accused is a child or a woman or a sick or infirm person, somebody a heart patient or somebody a cancer patient, somebody is suffering from grievous ailments, with medical report you have to make application before the court. It is, if he is kept in police custody for a period longer than so and so, it is likely that death will result. And by the time I go to the sessions court and high court, it may be too late. This honorable court may exercise the proviso to section 480 empowers the magistrate, a judicial magistrate, to grant bail even in cases of death, imprisonment for life imprisonment. Please note that very wide powers are given here under section 480. Then of course, there are many judgments which clearly says of the Bombay High Court, various High Court, if the offence is triable by the Court of Session, magistrate should not grant bail. In such cases, the party should preferably go to the Court of Sessions. The Court of Session powers are given under the provisions of section 483, where the High Court and the Court of Session grant bails. Please note that here they have special powers. The High Court and the Court of Session 483 mark kar le iske andar, in non-bailable offences, in cognizable offences, the High Court and the Session Court, they entertain the application without reservation, whether you are a child, woman, or a sick person, senior citizen, irrespective of whatever may be. Normally, when application is rejected, there is no need for you to go before the magistrate in such cases. If the offence is triable by the Court of Session, say a murder case or a rape case or a robbery case, you can directly make an application to the Sessions Court. You cannot directly go to the High Court. High Court will say that first you exhaust your remedy before the lower court forum, namely the Court of Session. So then High Court normally doesn't like to interfere directly. Of course, though the High Court and Session Court, they have parallel powers for granting anticipatory bail under the provisions of Section 482 BNS, which was equal to earlier Section 438 CRPC. But still, the High Court said that you go to the Court of Session. Anticipatory bails are only granted by the Court of Sessions and the High Court in its power under Section 482 Adv. 482 in respect of offences which are non-bailable offences. Kindly note that here. The offence must be non-bailable. Non-bailable, you cannot go for anticipatory bail in bailable offences to the High Court or Court of Session. Serious offences, before you are sought to be arrested. Now, which is the stage when you come to know that you should go to the Court of Session or a High Court to apply for anticipatory bail? That is the stage under Section 35(3), where the police officer gives you notice, earlier 41A of the CRPC, or your neighbor or your business partner may be threatening you that I will sue you in the civil court as well as teach you a lesson in the criminal court. You are apprehending arrest. The moment you are apprehending arrest, in many cases, the judges ask you the apprehension of arrest, what is the material you have got? Is there a FIR against you? Some judgments, some courts have taken the view that there is no need that there must be FIR. Even without the FIR, if the relations are very hostile, there is animosity between the parties, and one is trying to teach a lesson to the other by trying to wreak vengeance, though the matter is purely of a civil nature, are sought to be painted with a criminal color, and in such a scenario, the applicant has come before the court for an anticipatory bail. Your dignity will be spoiled. Your respect will be gone. So if you are arrested, that will undermine your status. Your liberty will be compromised. So this honorable court be pleased to grant me anticipatory bail. Isn't it? Anticipatory that you should not be arrested. The police officer has given me 41A notice under Section 35(3) of the BNSS. I have not committed any offense. Is a purely a civil transaction, or maybe the husband and wife relations are strained. The in-laws are trying to take revenge against me. These are such many cases where anticipatory bail can be granted. Normally in rape cases and murder cases, the courts do not like to grant anticipatory bail, but in murder cases, there is no bar. But you may say that the FIR does not disclose my name. So, that is a provision relating to anticipatory bail under Section 482, where the Court of Session and the Court of Session and the High Court grant bail. Of course, the Supreme Court of India in its SLP powers can grant the powers. There is no bar. Judicial magistrate, executive magistrate have no power to grant anticipatory bail. Okay? Please note that here. Yes. Then we also discuss the power relating to cancellation of bails. When the bails can be cancelled by the court, cancellation of the I'll just open this. So in application is the applicant has misused and abused the powers granting bail. If he has not complied with the terms and conditions of the bail, the victim or any representative can make an application to the court for cancellation. Isn't it? The court granting the bail has a right to also cancel the bail if the terms and conditions are violated. The bail bonds can be cancelled. Isn't it? Then you also should know that here, when the bails are granted, the provision relating to bail bonds and sureties come into play. Those powers are under Section 485, 486, 487, 489, 490 of the BNS, 444 से लेके 60 in the 459 in the CRPC, isn't it? That is the powers relating to the uh, grant of bail in bailable offenses, non-bailable offenses, and anticipatory bail. Yeah. Anybody want to ask me any question in this regard? I would like to keep this topic this much only, not expand. Further, we can do. Anybody has any question, please ask me. The leading judgments which you can take into consideration on this point are: number one, on the point of the remand application, then note down one: Central Bureau of Investigation versus Anupam Kulkarni, reported in AIR 1992, page number 1768. Page number 1768. Give me the judgment which I kept it here. Yeah. And the famous judgment of the Supreme Court, when the police officer is not registering a FIR, which is mandatory, Lalita Kumari versus Government of Uttar Pradesh, 2014 to SEC, page number 1, Constitution Bench judgment. You should keep in mind this judgment. Then judgment of the Supreme Court in Arnesh Kumar versus State of Bihar, that is reported in 2014 का है. Just give me the citation of Arnesh Kumar. Yeah, 2014, 2014, yeah, 2014 Supreme Court, page number 2756. Now this judgment brings on record the misuse of the provisions of 498A under the Indian Penal Code as to how, when matrimonial relationships are soured between the parties, how the wife, disgruntled wife, misuses the powers under 498A by filing complaints against husband, in-laws, all relations, and how they were sought to be arrested. See, the Supreme Court gave directions to the police officer not to arrest in such matrimonial offences arbitrarily. You must give notice. That is how 41A notice provisions came into light here. Please note that here. उससे पहले the Supreme Court laid down guidelines directing the report of the National Police Academy, that is in Jogendra Kumar versus State of UP, in what cases the police officer can arrest and where their grounds are required to be furnished. That is Jogendra Kumar case is reported in 1994, AIR 1994, page number 1349. It's a landmark judgment authored by Justice S. Mohan. Yeah, Arnesh Kumar S. Mohan. Here, an advocate who was a young advocate was arrested by the UP police, taken for investigation, not produced before the magistrate for 5 days. The law mandated that within 24 hours the arrested person must be brought. Then the brother made inquiries with the police. Kya ho gaya? The police did not give any reply. Then he was compelled to file habeas corpus petition directly in the Supreme Court. When the habeas corpus petition was filed, the police authorities came. We never arrested him. We only took him for inquiries. Detention में लिए थे. We were not actually not shown as arrest, but we sought his assistance for arresting some accused person. But the Supreme Court said that you cannot arrest. You keep a person in custody for 5 days without giving grounds of arrest in the matter. Please note that. Now you also must be knowing that here, when a public servant is arrested or sought to be arrested, information must be given to the superior officer. Suppose, for example, the police want to arrest a magistrate or a civil judge, they cannot arrest without giving intimation to the High Court, isn't it? That is how. Similarly, the member of parliament cannot be arrested without giving intimation to the to the uh, speaker or a chairman of the parliament. There are guidelines given. There's also rules under 229 of the parliamentary procedure are given that year. You must be knowing a famous case of Gujarat where the magistrate was arrested and paraded by the Gujarat police, isn't it? That is a reported judgment. Please see that here. Because the police, the magistrate was a very strict magistrate, honest magistrate. He used to fire the police officer as to why you are not producing the accused person in time, why investigation done. The senior police officer who had were bearing a grudge against him invited him as a chief guest, but made him drink wine, forcefully made him drink, and handcuffed him and paraded in the streets of Anand at Gujarat. So that judgment reported the Supreme Court suspended the police officers and given guidelines when a when a magistrate is sought to be arrested, what guidelines are required to be done, and it cannot be done in a cursory manner and arbitrary arrest. Okay. Anybody want to ask me any question? Please ask me. These are the leading authorities. पूछ लीजिए any question.
Sir, is bail is granted by JMFC, then cancellation has cancellation of the bail is bail, that power is with the JMFC or a higher court also, session court.
Session Court of Sessions normally give. Now the new BNSS, the acts say that the magistrate has wide powers. You can also go before the magistrate's court and make such application. Formally, there was no provision before the magistrate for going for a discharge of the accused person in someone's cases. Now there's a provision. Now the amended CRPC, the BNS gives wide powers. So there is no bar under the CRPC or BNS from going to the magistrate seeking cancellation of the bail. Otherwise, you have to go before the Court of Session for cancellation.
There's a question: how to quash the notice of magistrate for the forfeiture of property?
Forfeiture of property. Open section. Yeah. Forfeiture of property is covered under. That is a provision directly you have to go to the High Court. When a forfeiture take place, see the provision relating to forfeiture under the CRPC and the BNS. You may be a great writer. Your books have been published. According to the police officer, the state government, it contains scandalous material. It has the effect of creating law and order problem. Your novel or book will be confiscated by the police officer, isn't it? Now the provision normally here is that here you will have to make application to the High Court directly. This is one case which directly goes to the High Court.
Forfeiture procedure and bond has been forfeited.
No, case. Forfeiture of these. Not bad. Forfeiture of Article C, when a person can directly move the High Court. That is one provision in CRPC, just only where a person can directly move the High Court. In the cases of forfeiture, where the articles, newspaper, books have been confiscated, in the appellate jurisdiction of the High Court, you directly file a petition that will be under the provisions of Section 482 CRPC. CRPC ka 482 is now amended to, the new section is Section 528. Inherent powers of the court. आप चेक कर लीजिए उसके अंदर भी है. There is a specific provision in that. I taught it in the during in the government law college. They see forfeiture.
Property in certain cases.
Yes. Section
105.
No, forfeiture of property in certain cases. Forfeiture of It's a forfeiture of this one. Yes. In other cases, for forfeiture of your article take place, you have a right to go before the magistrate. You have a right to go before the court of session, depending upon the nature of the case and where the trial is triable, whether it's a summons trial, warrant trial, or a trial before a court of session.
Somebody asking,
What is the question next?
sir, if at the remand stage a magistrate denies bail, can there be an appeal against his order?
You can directly go to the sessions court, present the application. Application for bail to the magistrate in the court of session. These are interlocutory order. There is no provision for appeal, but you have a right to go to the court of session.
There is another question.
You have a right to go to the court of session for bail. Under the provisions of section 480, it will be regarded as a second bail application. There is no need to file an appeal against this. You have a right to go to the court of session and make an appeal, the second bail application. If the session court rejects it, you have a right to make a third application to the high court, a bail application. And we don't normally call it an appeal, it is application for bail. You may say that here concurrent finding, there are two concurrent applications which have been dismissed by the court of magistrate as well as the court of session. The third application is being filed before the high court. And if the high court rejects it, you go before the court before the Supreme Court by way of special repetition under Article 132, 133. The Supreme Court has a power to entertain application. Yeah, any other question, Jesse?
What is interlocutory orders?
Hmm?
It would be great if you guys turn your mics on and ask questions.
Who says? Yeah, please turn your mics on and ask question. I will directly answer you. Writing is I find it very difficult to read it, cumbersome. Directly ask me question from your mic.
So what are interlocutory orders? Please explain.
Interlocutory orders are orders which are passed during the pendency of proceedings, such as court appoints a commissioner, court grants an order of injunction, court passes appointed some officers to inspect. These orders are basically passed during the pendency of a case.
So can they not be described as interim orders?
Yeah, they are interim orders, interlocutory. Interlocutory orders are same. There is no difference between it. Interlocutory orders are passed during the pendency of a matter. In the civil cases, but during the pendency of a suit, like example, order under Order 39, Rule 1.2 and CRPC, order appointing a commissioner, order appointing a receiver, they get order appointing various interlocutory orders. In the CRPC, the court may appoint an officer um, for the purpose of investigation, for the purpose of determining the handwriting expert, appoint an officer, take his opinion, and finding out the expert is special opinion is sought of the doctor during the pendency. The court passes certain orders, and order of bail is also interlocutory order.
But
Order
can
granting the
interlocutory
bail
orders
is
be challenged by?
interlocutory order.
Sorry, can interlocutory orders be challenged by way of revision petition, or it can't be challenged?
Yes, there is. If they can be challenged if they are affecting your fundamental, if they are affecting your rights. Under 397 CRPC, under Section 401 CRPC, they can be challenged. There is no bar as such.
And so
For
what is the
example,
difference?
order framing a charge is an interlocutory order. Order framing additional charge is an interlocutory order. Order recording a plea is an interlocutory order, but they can be challenged because they are affecting your rights. Under 211 CRPC, the court frames charges. Additional charges can be framed.
There is another question.
Hmm.
Can we proceed?
So this last question is, can you distinguish between sessions tribal and warrant tribal cases?
That topic we had taken last time. You have not seen my last lecture, I think.
No,
Huh? Please,
no, I was late.
please
Okay,
see my
sorry.
last lecture again. I will take it. The time may not be permitting today. Huh?
Okay, thank you.
Last lecture we have covered this topic: session trial and some warrant trial.
There's a question, sir. At the remand stage, the magistrate denies bail. Can there be an appeal against this order?
At the remand stage,
The magistrate denies bail, and can there be an appeal against this order?
no, at the remand stage, a bail is not granted. You have a right to make an application under the provisions of section 437 or before a magistrate. It's a continuous right which you have a right to make it at any stage. At every stage, you can make the bail application. If the bail application rejected under the remand provision, namely under the provisions of section 187, you have a right to make application to the magistrate under the provisions of section 430, say section 478, 479, and 480. A remand order can be questioned by you in the court of session, in the High Court, by filing a writ petition under 482 CRPC, inherent power. There are many people who go to the High Court. The remand granting 15 days, 20 days is way too harsh. It may be reduced. It violates my fundamental right under Article 21 of the Constitution of India.
Another question, under section 99 of BNSS, within 2 months, application to High Court under section 99 of the BNSS within 2 months.
Section 90.
99
Mm.
of BNSS.
Detention and search.
Application to High Court
Application to High Court.
under section 9.
Discontinued. All of you present are gone.
There are
कोई हैं available?
Yeah, there are 13 participants. I'll put a message on the
Yeah, you may please resume your questions. I will answer. Come here, please.
Yes, I'll drop a message.
Sir, can we directly approach the High Court by surpassing the session court jurisdiction in case of anticipatory bail?
No, the you can go. There are the corresponding. There are parallel powers between the High Court and there is no bar. But most of the High Courts say that you first go to the lower court and then you come to us. The High Court judges don't like you approaching them directly, because I have seen that some of them grant it. It's not that there is no bar. There is no hard and fast rule. It's like jurisdiction under Article 226 of the Constitution. The High Court may issue a writ or not. The High Court may tell you you go and file a civil suit. So, it's a discretion of the judges.
Okay, sir.
But there is no bar. There is no bar. Now, when you read the provisions of section 400 and section 480, 82, say when any person release reason to believe that he may be arrested on accusation of having committed so and so offense, and a high court or a court of session make direction. See that subsection 2 says that when a high court or the court of session may make a direction under subsection 1, it may include the condition that direction in the so and so. So both the courts are mentioned here, high court and the court of session. But order of priority, we normally go to the lower court first. But some high court judges grant it. It's not that. There is no prohibition as such. When there is no prohibition, the courts may entertain.
But sir, they are very reluctant in granting anticipatory.
Some of them are also, they grant it. It is all because some you have to find, you have to be vigilant and find out which judge is liberal, which judge is immoral. They are all human beings. You can't expect them to listen to you all the time you want. You have to see the judge's discretion. Find out from the bar whether this particular judge is granting discretion directly entertaining or go before the court of session. I remember one particular judge in the High Court. She used to never entertain revision application directly in the High Court. She used to say that first go and file. How to disconnect it? Because you told me I had on it.
Recording in progress.